This is The Briefing, a podcast presented by Mussio Goodman Law Firm.
Under the legislation called WESA, W-E-S-A, if you are a child of a deceased, if you're the spouse of the deceased, or if you're the parents of the deceased, you have an opportunity to vary the will. So for example, if a child is disinherited, and as long as the child is a legally adopted child or a naturally born child of the deceased, then the individual have an opportunity to dispute the will. And what the courts generally look at in those situations is whether or not the deceased met the legal and moral obligation of providing for the child. And in terms of spousal requirements, there's some significant law that indicates that you have to provide for your spouse, and it's almost the first comparative approach is exactly this. What would have happened had you divorced on the day of the death? And so that's called the legal obligation. You have to basically provide for your spouse, and there's also a moral obligation. And there's also the opportunity of parents in some instances to equally try to vary the will if they're not provided for. So if you come across a will where you've been excluded, have a look at the will, determine who is in the will, and you should ultimately talk to a lawyer to decide whether or not you have a claim to vary the will.